So which are the teachings that the Brussels IIb has provided, and that have been learned and have been enshrined in Brussels IIter? So, of course, the most disruptive innovation of Brussels IIb was this the idea of abolishing exequatur for the area of freedom, justice, and security. So there is this distinction we all know about between urgent decisions, privileged decisions that are enforced immediately and normally at the same conditions among within the issuing state and within the whole external, the whole area. Whereas ordinary decisions, more long-lasting ones, are subject to the more traditional system. 6 years later, this distinction between urgent, privileged decision and ordinary one was made also in the maintenance regulation. And it's perhaps no coincidence that both of these regulations are regional. They set regional systems of coordination that in a framework that is larger, and which is the framework of the Hague Convention. So I refer, of course, to the 1980 Hague Convention, but also to the 2007 Child Support and Family Maintenance Convention. So the Brussels IIter now goes even further. It somehow acknowledges the positive experience of abolition of exequatur in terms of cost of the procedure, timing of enforcement, administrative ease for the victims of a wrongful removal, or at any rate for a wrongful separation of a child with its parent. However, I guess that one of the reasons for the recast was also a global dissatisfaction with the rigid scheme of the overriding mechanism. So in this respect, there are very polarized views that maybe are also gendered, in my opinion, as to the expediency of maintaining the overriding mechanism. So the opposition between the views existing in respect of this mechanism have resulted in a failure openly to address the problem and resolve it once and for all in the recast. So timid steps have been made, however, in order to enable member states to protect the child without violating the constitutional principle of freedom of circulation of judgment. It is certainly difficult to protect at the same time constitutional principles that have the same rank and go in opposite directions. However, one could argue that administrative needs should never prevail over the need to protect the vulnerable. So some steps needed to be taken to reconcile the will for prompt EU-wide enforcement and respect for the best interest of children. Here, I would like to indulge on the what it means enforcing a decision on a child. So the recast eventually adopted the following ideas. There is a certain improvement of the, in my opinion, of the overriding mechanism, because it's I will not indulge in this because there will be a seminar more precisely dedicated to this. But there is an improvement also because the gap between ordinary and privileged decision has been squeezed by a more general abolition of exequatur, of course, mainly as regards of parental responsibility, as Michael pointed out, because divorce, separation, and all other issues concerning the breakup of a marriage are mostly covered by other regulations, the 2009 regulation, the 2016 regulations. At the end of the day, divorce decrees and similar ones, they do not need properly to be enforced, but just recognized. Here, the new regulation innovates in two respects. Firstly, because it reacts to it clarifies, which the Brussels IIb regulation didn't do, how the recent legislative trends in favor of privatizing divorce proceedings can be characterized in the regulation. So the increased recognition of party autonomy in family law and a sounder awareness of the phenomenon such as that of life-consuming divorces, procedures of divorce, with the collateral negative consequences for the efficiency of the judiciary, have led member states, also in Italy, Michael spoke about France, to allow married persons to divorce privately with intervention of the lawyers. So these rules not always prescribe that the act of divorce will be enshrined in an authentic instrument, nor do they provide for the necessary intervention of a judicial authority. So as a consequence, there were some doubts whether they could benefit of the fifth fundamental freedom. And the problem appeared with the case that was already mentioned, Sayuni, in the context of a Sharia repudiation. Of course, there are substantial differences between Sharia unilateral repudiation and a privately agreed divorce, but the case did contain teachings for the recast. So with the recast, private agreements of divorce recorded by a public authority, authorized, notified by the Commission, will benefit of the same rules as authentic acts, as it has been said. On another note, the regulation also addresses a need for clarification that came to light with the Matruskova case. So there it was necessary to adopt a measure for the protection of a child, the appointment of a guardian in relation to an agreement for the sharing out of an estate. Now, Article 7 clarifies that the court sees for a succession procedure may also be vested with this incidental issue related to parental responsibility. Needless to say, its decision will not be exported and will remain confined to the needs of the procedure. Moving on, sorry for I skipped this line. Maybe the most striking improvement of the regulation consists in the extension of the abolition of exequatur that it adopts. So such an extension does not affect the distinction between privileged and ordinary decision. The distinction remains because the real and radical abolition of exequatur only concerned the following, the former. Ordinary decisions, so will still be subject to an exequatur procedure. However, this is non-compulsory. So it will only take place if the party opposing it introduces one of the grounds of refusal. So now, privileged decision and ordinary decision also have different grounds for refusal. These are strictly limited for urgent decision to the need to rectify a mistake, to the need to prevent contradictory orders. For all the other decisions, the classical grounds for opposing recognition remain intact. There is also an additional insertion of the ground consisting in the decision having been taken without the children involved having been given the opportunity to express their views on how they wish to continue to live and with whom and where. So in the previous regime, this was mostly part of public policy, with the result that every state would interpret it according to its own standards. So another differentiation of regime affects the circulation of acts as a result of the plurality of instruments applicable to matters related to a divorce. It suffices to say that the Article 46 of the recast of 2003. So I'm talking about Brussels II bis. Has been now substituted by 5 articles in Brussels IIter. So despite the commendable goal of allowing the free circulation of private divorces, as it has been observed, there are risks inherent with this circulation. But on the other hand, most of the topics will be covered by other regulation. So, and I am a little bit perplexed on the introduction of indirect rules of jurisdiction for authentic acts and private divorces. And I would like to have your views, the views of my colleagues that will speak after me also on this, because this means the introduction of indirect rules of jurisdiction. On the one hand, it's supposed to prevent parties from lawful divorce shopping. So this phenomenon is known. It integrates a sort of fraude à la loi, because there are agencies that are advertising themselves on the web in order to propose to counterfeit connecting factors in order to enable a couple to access the divorce services, legal services, but also judiciary in their countries to reduce the cost of proceedings. So the introduction of these rules is maybe aimed to prevent this phenomena, but many doubts can be raised on this. As regards the most delicate point, which Mary touched upon also, we all know that INCADAT, the database of the child abduction section of the website of the Hague Conference, offers a tragic collection of cases testifying of various judicial stratagems to escape the overriding mechanism in the best interest of the children involved. Assertedly. So the most famous and divisive of this case I already mentioned is Neulinger and Schuruk. Now, the new regulation contains rules aimed at lowering the emotional tension between the courts involved in child abduction proceedings. Understandable socio-cultural reasons, which I cannot enlarge upon here much as I would like to, have constantly led the courts of origin and the courts of refuge to be pitted against each other, sometimes in even a more vehement way than the parents themselves. That's the feeling I had in reading some judgment. The recast now attempts to transform this anti-juridical attitude of member states' courts into one of judicial cooperation, not only by enhancing the chances of communication between courts, we will see it better in further seminar, but also setting harmonized norms on enforcement. So the enforcement, it's been already said, may be suspended according to Article 56.4 if it may cause an irreparable harm to the child. More precisely, the rule takes the wording of Article 13. So this is in conformity with the principle of subsidiarity. The judge most close to the child is better placed to evaluate the child's situation in that particular moment of enforcement. So this rule represents, in my view, a tiny yet very important enhancement in flexibility as regards the jurisdictional power of the member state of refuge. And contrary to my colleague, I think it will enhance mutual trust, because it will have the effect of promoting collaboration between the judges and not continue with this idea that they are pitted against. Because de facto, it means that the state of the destination is no longer in a position of total subjugation. So this was a humiliation that was very badly perceived by member states' courts and led to infamous escape stratagems. Only case law will definitely say, identify the positive and negative aspects of the critical changes of the recast in respect of this rule on enforcement. So at first sight, it is easy to argue against the proliferation of rules. It has already been done. And proliferation inevitably leads to inconsistency and sophistication. Lawyers and judges are now confronted with a multiple choice of exequatur procedures, so that the normal one, the light version prescribed for ordinary decisions of the recast, the zero version experimented by privileged decision, we will have to see. And on a final note, the recast will also be a test for the tenure of the new system of enforcement of privileged decision in cases of gender-based violence. The European Parliament's Committee on Petitions seems to have had many such complaints. And there was even a suggestion to mention, to have rules, specific rules on this. Time will tell whether the new enforcement rules will prove more efficient in enhancing the quality of life of victims of gender-based violence. We will have to see